Digitel VPROV. Of Pangasinan. Facts: the present petition stemmed from a complaint for mandamus, collection of sum of money and damages instituted by the province of Pangasinan against Digital Telecommunications Philippines Incorporated. Section 137 LGC withdrew any exemption from the payment of franchise tax by authorizing the LGUs to impose a franchise tax on businesses at a rate not exceeding 50% of 1% of the gross annual receipts of. Section 232 LSO authorizes the imposition of an ad valorem tax on real property by the LGUs within the metropolitan Manila area wherein the land, building, machinery, and other improvement not thereafter specifically exempted. Digitel was granted, under Provincial Ordinance No. 18-92, a provincial franchise to install, maintain, and operate a telecommunications system within Pangasinan. Under the Sector 6 of the provincial franchise, the grantee is required to pay franchise and real property taxes. The Sangguniang Panlalawigan also enacted Provincial Tax Ordinance 1. Section 4, however, expanded the application of Sector 6 of the provincial franchise of Digitel to include machineries and other improvements, not thereafter exempted. Provincial Tax Ordinance No. 4 was then enacted. Sections 4, 5, and 6 positively imposed a franchise tax on businesses enjoying a franchise within the province of Pangasinan. Thereafter, Digitel was granted by RA 7678 a legislative franchise. Under its legislative franchise, particularly Sections 5 thereof, petitioner Digitel became liable for the payment of a franchise tax as may be prescribed by law of all gross receipts of the telephone or other telecommunications businesses transacted under it by the grantee, as well as real property tax on its real estate and buildings exclusive of this franchise. Later, the province of Pangasinan found that Digitel had a franchise tax deficiency for the years of 1992, 1993, and 1994. In the interregnum, on March 16, 1995, Congress passed RA 7925, otherwise known as the Public Telecommunications Policy Act of the Philippines. Section 23 of this law, entitled Equality of Treatment in the Telecommunications Industry, provided for the ipso facto application to any previously granted telecommunications franchises of any advantage, favor, privilege, exemption or immunity granted under existing franchises, or those still to be granted, to be accorded immediately and unconditionally to earlier grantees. Thereafter, Digitel opposed Pangasinan's claim on the ground that prior to the approval of its legislative franchise, its operation of a telecommunications system was done under a facilities management agreement it had previously executed with the DOTC. It clarified that since the facilities in Pangasinan are just part of the government-owned facilities awarded to Digitel, not only did the DOTC retain ownership of said facilities, the latter likewise provided for the budget for expenses under its allocation from the government. Hence, all revenues generated from the operation of the facilities inured to the DOTC, and all the fees received by petitioner Digitel were purely for services rendered. Further, it argued that under its legislative franchise, the payment of a franchise tax to the BIR would be in lieu of all taxes on said franchise or the earnings therefrom. The PRONVINS of Pangasinan filed a complaint for mandamus, collection of sum of money and damages before Branch 68 of the RDC of Lincoln, Pangasinan. The trial court decided the province. It ruled that Digitel's legislative franchise does not work to exempt the latter from payment of provincial franchise and real property taxes. It ruled that provincial and legislative franchises are separate and distinct from each other. Moreover, it pointed out that LGH already withdrew any exemption granted to anyone. On the other hand, Digitel maintains that its legislative franchise being an earlier enactment, by virtue of Section 23 of Republic Act No. 7925, the ipso facto, immediate, and unconditional application to it of the tax exemption found in the franchises of Globe, Smart and Bell. Stated simply, Section 23 of Republic Act No. 7925, in relation to the pertinent provisions of the legislative franchises of Globe, Smart, and Bell, the national franchise tax for which Digitel is liable to pay shall be in lieu of any and all taxes of any kind, nature, or description levied, established or collected by any authority whatsoever, municipal, provincial, or national, from which the grantee is hereby expressly granted. Issue 1. Digitel is exempt from the payment of provincial franchise tax in view of Section 23 of RA 7925 in relation to the exemptions enjoyed by other telcos. Held no ratio. Prior to the enactment of its legislative franchise, Digitel did not enjoy an exemption from the payment of franchise and real property taxes. In fact, the provincial franchise made Digitel liable for the payment of such taxes. The case at bar is actually not one of first impression. Indeed, as far back as 2001, this court has had the occasion to rule against the claim for tax exemption under RA 7925. In the case of PLD-TV, City of Davao, we already clarified the confusion brought about by the effect of Section 23 of Republic Act No. 7925, that the word exemption as used in the statute refers or pertains merely to an exemption from regulatory or reporting requirements of the DOTC or the NTC and not to the grantee's tax liability. In said case, the court ruled that Congress did not intend Section 23 to operate as a blanket tax exemption to all telcos. Moreover, tax exemptions must be expressed in the statute in clear language that leaves no doubt of the intention of the legislature to grant such exemption. And, even if it is granted, the exemption must be interpreted in strictissimi juris against the taxpayer and liberally in favor of the taxing authority. Moreover, it ruled that PLDT's theory will leave the government with the burden of having to keep track of all granted telecommunications franchises, lest some companies be treated unequally. It is different if Congress enacts a law specifically granting uniform advantages, favor, privilege, exemption, or immunity to all telecommunications entities. RA number 7925 is thus a legislative enactment designed to set the national policy on telecommunications and provide the structures to implement it to keep up with the technological advances in the industry and the needs of the public. The thrust of the law is to promote gradually the deregulation of the entry, pricing, and operations of all public telecommunications entities and thus promote a level playing field in the telecommunications industry. There is nothing in the language of 23 nor in the proceedings of both the House of Representatives and the Senate in enacting RA number 7925 which shows that it contemplates the grant of tax exemptions to all telecommunications entities, including those whose exemptions had been withdrawn by the LGC. The issue is then settled. The court has no recourse but to deny Digitel's claim for exemption from payment of provincial franchise tax. The foregoing pronouncement notwithstanding, in view of the passage of RA 7716, abolishing the franchise tax imposed on telecommunications companies effective January 1, 1996 and in its place is imposed a 10% VAT, the in lieu of all taxes clause/provision in the legislative franchises of Globe, Smart and Bell, among others, has now become functus officio, made inoperative for lack of a franchise tax. Therefore, taking into consideration the above, from January 1, 1996, Digitel ceased to be liable for national franchise tax and in its stead is imposed a 10% VAT in accordance with Section 108 of the Tax Code. Issue 1. Digitel is exempt from payment of real estate tax under its legislative franchise. Held no ratio. Pertinent provision, Section 5. Tax provisions. the grantee shall be liable to pay the same taxes on its real estate, buildings, and personal property exclusive of this franchise as other persons or corporations are now or hereafter may be required by law to pay XXX. Owing to the phrase exclusive of this franchise, Petitioner Digital stands firm in its position that it is equally exempt from the payment of real property tax. It maintains that said phrase found in Section 5 qualifies or delimits the scope of its liability respecting real property tax, that real property tax should only be imposed on its assets that are actually, directly and exclusively used in the conduct of its business pursuant to its franchise. According to the province, however, the phrase exclusive of this franchise in the legislative franchise of Digital did not specifically or categorically express that such franchise grant intended to provide privilege to the extent of impliedly repealing RA 7160. Thus, the question is, whether or not Petitioner Digital's real properties located within the territorial jurisdiction of respondent province of Pangasinan are exempt from real property taxes by virtue of Section 5 of Republic Act No. 7678. We rule in the affirmative. However, it is with the caveat that such exemption solely applies to those real properties actually, directly, and exclusively used by the grantee in its franchise. The present issue actually boils down to a dispute between the inherent taxing power of Congress and the delegated authority to tax of the local government borne by the 1987 Constitution. In the PLDTV City of Davao, we already sustain the power of Congress to grant exemptions over and above the power of the local government's delegated taxing authority, notwithstanding the source of such power. Had Congress intended to tax each and every real property of Digital, regardless of whether or not it is used in the business or operation of its franchise, it would not have incorporated a qualifying phrase, which such manifestation admittedly is. And, to our minds, the issue in this case no longer dwells on whether Congress has the power to exempt Digital's properties from realty taxes by its enactment of RA 7678, which contains the phrase exclusive of this franchise. In the face of the mandate of the Local Government Code, the more pertinent issue to consider is whether or not, by passing RA 7678, Congress intended to exempt Digital's real properties actually, directly, and exclusively used by the grantee in its franchise. The fact that Republic Act No. 7678 was a later piece of legislation can be taken to mean that Congress, knowing fully well that the Local Government Code had already withdrawn exemptions from real property taxes, chose to restore such immunity even to a limited degree. In view of the unequivocal intent of Congress to exempt from real property tax those real properties actually, directly, and exclusively used by Petitioner Digital in the pursuit of its franchise, Respondent Province of Pangasinan can only levy real property tax on the remaining real properties of the grantee located within its territorial jurisdiction not part of the above stated classification. Said exemption, however, merely applies from the time of the effectivity of Petitioner Digital's legislative franchise and not a moment sooner. In fine, Petitioner Digital is found accountable to Respondent Province of Pangasinan for the following tax liabilities: 1. As to provincial franchise tax, from November 13, 1992 until actually paid. And 2. As to real property tax, for the period starting from November 13, 1992 until December 28, 1992, it shall be imposed only on the lands and buildings of Petitioner Digital located within the subject jurisdiction. For the period commencing from December 29, 1992 until February 16, 1994, in addition to the lands and buildings aforementioned, it shall similarly be imposed on machineries and other improvements, and by virtue of the national franchise of Petitioner Digital or Republic Act No. 7678, in accordance with the court's ruling in the above-mentioned buy and tell case, from the date of effectivity on February 17, 1994 until the present, it shall be imposed only on real properties not actually directly and exclusively used in the franchise of petitioner Digitel. In addition to the foregoing summary, pertinent provisions of law respecting interests, penalties, and surcharges shall also be made to apply to herein subject tax liabilities.